Hi everybody and welcome to Help Solve the Case. We are here discussing part 4 of the Richard Allen appeal, the Delphi murders, what the defense says the state and the court got wrong. If you don't know me, I'm Christine Burke. Thanks for being here. I'm a retired police detective and sergeant. I am a current law enforcement expert witness, which means I go into court and I testify about things just like this. So we're taking a look. I haven't really been involved in the case. I'm reading along with these pleadings and I'm providing commentary and hopefully some explanation as I go along. So thanks for being here and joining me. I really would appreciate a like, a share, and a follow if you would consider it. I really appreciate you being here. So we're following along here talking about some of the key issues, one of which is what the defense is saying here, that the defendant's pre-trial solitary confinement was psychological coercion, okay? Meaning that we were talking about it led to mental psychosis, and certain confessions, what the state called confessions, came out, and the defense is saying, not so fast, okay? Because we, from watching TV and different things, we think about confession, you know, the old joke would be beating someone with a telephone book to get them to confess. And in this case, the jail cell, the solitary confinement is that telephone book, okay? So let's see what they're alleging here. So they're saying that Allen's solitary was psychological coercion because it was prolonged, caused psychological pain, and put him at the mercy of the state. The prolonged nature is coercion because the solitary confinement can bring a person, quote, to the edge of madness, perhaps to madness itself. And they're showing a case citation here from a previous case. And I apologize, I am recovering from bronchitis, so I may hack and I may drink a little bit. So thank you for understanding. They say here that solitary causes psychological trauma, including psychosis, hallucinations, and paranoia. They say from day one at WCU where he was held. Now this is not after conviction. This is after he was arrested. That he was placed in a, quote, strip cell, end quote, which is a stripped down cell. They describe it, the most restrictive cell in the most restrictive solitary unit, with only bare essentials and a camera constantly recording him. Soon thereafter, IDOC, that's, I believe, the Indiana Department of Corrections, ordered guards to videotape him when out of the cell, including showering and attorney visits. Suicide companions remained outside his door, documenting everything, regardless of suicide watch status. Now that's interesting. So typically, you know, in different situations, I can say typically, in different situations, they will put people on suicide watch when they're first arrested, okay? But this here, the language, again, this is what the defense is asserting. They're saying suicide companions remained outside his door, documenting everything regardless of his status. So that to me means, like, did he not have status at some time? We don't know. And it says he had no contact with anyone unless caged or chained. The sensory deprivation, social isolation, and forced idleness is difficult even for healthy people. And then they talk this case here. I'm not going to try to pronounce that last. Gudjonsson. They talk about where a healthy man wrongfully implicated and detained in solitary questioned his memory and suspected he committed the crime. Though he stayed sane by reading, exercising, and praying, the experience traumatized him. Early videos show Allen pacing his 8.5 by 12.5 cell, laying down, doing leg crunches, reading, writing, and looking distressed. Within 2 weeks, Allen said he was, quote, broken, end quote, and told his wife, quote, if this becomes too much for you, call the detectives and I will, ... tell them whatever they want to know, end quote, okay? And that's within apparently 2 weeks of being arrested and placed in solitary. They say, had his solitary been 30 or even 90 days, he would not have decompensated. But it was 13 months. That's got to be crazy. It's got to be crazy. The prolonged solitary caused Allen, quote, predictable, end quote, psychological pain, paranoia, nightmares, memory problems, and confusion. And I will tell you, I've worked with some defendants that have been in solitary, and they tell me it is not good. It's not good. I don't know. I'm not a specialist in that area. But I know people that have been through it, for even short periods of time, and they don't like it. They don't like it. So it says here, it is undisputed Allen deteriorated to being, quote, gravely disabled, end quote, and, quote, very psychotic, end quote. And the IDOC involuntarily administered antipsychotics between April and late June. Although Walla, that was I think it's a mental health doctor we talked about in the previous sessions, noted concerns about feigning, which is like faking. She diagnosed psychosis and suspected incompetence and over-medication, right? So this seems to be here would be an important word for the confession, right? We hear incompetent to stand trial, right? So here's incompetent. So if he was incompetent during this period, would he be able to make a true confession? Just talking it out, right? And WCU only monitored Allen's mental health. Talking with a psychologist while shackled in a cage is not treatment. Solitary put Allen in a constant state of vulnerability. Solitary confinement has long been recognized as psychologically coercive, equated to, quote, rack, the thumbscrew, and protracted questioning, end quote. And they quote a Florida case there. Pretrial solitary's, quote, punishment, end quote, already underway and, quote, conveys, ... without the necessity of spoken words, the implied threat of further punishment, end quote. It does not matter why a defendant was in solitary, whether justified or whether the prison planned further punishment. In this harsh environment, Dr. Walla controlled all aspects of Allen's life, including whether he got bedding, clothes, meal items, books, personal items, and utensils. She could provide a new window and a tablet or strip him to bare necessities. Privileges were contingent on pleasing her. Whether Walla had ill intent is irrelevant. It is what Allen thought and what solitary confinement did to him or would do to many of us. So, are they saying here that he would do whatever he had to do to please her because she controlled the blankets and stuff? Is that what I'm reading there? After confessing to Walla on May 3rd, he asked for his property back. And she indicated she needed more consistency. Quid pro quo. Yeah? What do you think? Senator McCain, a prison camp survivor, explained solitary, quote, crushes your spirit and weakens your resistance more effectively than any other form of mistreatment, end quote. Allen entered solitary confinement compromised. He left broken. It says Allen's confessions were a product of solitary-induced psychosis, not rational intellect. IDOC records show that Allen continued to suffer from psychotic something during the times he confessed. On April 5th, when he confessed to Dr. Walla, he was not eating or sleeping and was drinking from the toilet. On May 3rd, when he confessed, Allen had symptoms of paranoia and disorientation. Despite Walla claiming he presented as, quote, more organized than he has been, end quote, the day before he was confusing nightmares with reality and claiming to have started World War III. 2 days before, he was too disjointed to hold a conversation. Days earlier, he covered himself in feces and claimed he was King Michael. His confessions to guards occurred during bizarre and psychotic behavior. Guards believed he was faking, but they are not clinicians, and Dr. Westcott found no malingering through objective testing. Allen confessed to his family on April 3rd, May 10th, May 17th, May 25th, and June 11th. On April 3rd, he also fell on the floor, asked if he was dead, and was suicidal. On May 10th, he believed he was dead, that the world would blow up if he slept. His water was poisoned, and he was reliving the same day. On May 17th, he was paranoid of attorneys and staff with Odin patches. On May 25th, Allen paced for 2 hours and banged his head. On June 11th, he thought he was in hell and did not understand what was happening. In August, Allen did not remember confessing or weeks of early April. Throughout, he complained of memory loss. State action overbore Allen's will. Allen did not confess until after 5 to 7 months of solitary. Before arrest, he consistently denied involvement. Dr. Westcott opined Allen's psychosis was caused by the stress of solitary confinement on a pre-existing illness. Dr. Walla agreed that, quote, a lot of the time, end quote, solitary confinement exacerbates mental illness, and it is reasonable to believe Allen's confinement caused his psychosis. And I think we saw, I don't know if it was the last video, Walla agreed that she might have changed her opinion. I think it's a she. Okay. The social isolation of solitary makes people question their, quote, self, end quote. If you are treated like you are guilty, you begin to think you are. Dr. Gracian testified a false memory starts with a belief. In his first confession to his wife, Allen said, quote, I think I did it, end quote. In his first confession to Dr. Walla, he was unsure if he had sex with the girls. Allen got facts wrong and confessed to crimes he did not commit. Allen claimed he shot the girls. The Indiana Constitution, the state failed to prove Allen's statements were a product of rational intellect rather than the state's misconduct. So they're saying this confinement was misconduct. The Indiana Constitution also protects against the admission of involuntary statements. Okay, so they're going to say involuntary because they were coerced from the confinement. Indiana's test is like the due process standard, requiring a confession to be, quote, freely self-determined, end quote, by a, quote, rational intellect and free will, end quote. However, it is more robust because it requires the state to prove voluntariness beyond a reasonable doubt. Okay, so the burden goes on the state. So they're going to have to show how it wasn't causing psychosis and all that stuff. It says also it does not require state action to be coercive to overcome a mentally ill person's will. Okay, and they've got a case here. They said, in this case, the mentally ill defendant's statement was ruled involuntary due to his altered state and confusion, although officers neither coerced him or knew of his illness. But mental illness alone will not render a statement involuntary. It says there must be some state negligence that contributed to overcoming the defendant's rational intellect. In this case, police gave confusing or inadequate warnings, the Banks case. Okay. So in this case here, Richard's case, they're saying here the IDOC's refusal to apply their 30-day policy to Allen and to transfer him after he's deteriorated is at minimum negligent. Okay, so that's the bad act. And this caused Allen's psychosis and confessions. And the prosecutor's delay and the trial court's refusal to set a timely hearing exacerbated the deterioration. This is conduct that our Constitution cannot tolerate, regardless of whether it constitutes coercion under federal due process. Also, the evidence does not show the statements were a product of rational intellect beyond a reasonable doubt. Allen was considered gravely disabled through June 16th when he received his last emergency injection due to self-harm. Though Wallace sometimes described Allen as more coherent or his symptoms not significant, the state cannot have it both ways. Allen decompensated to the point of forced medication, but remained rational beyond a reasonable doubt, right? So if they're having to give him this medication to make him rational, he can't be rational, right? So they say even if he could occasionally hold a conversation, it does not render his confession voluntary. So now they're saying even if the court finds Allen's statements voluntary, they are a product of unconstitutional detention. And they say Allen's prolonged solitary confinement violated Article 1, 12, and 15. And I believe that's the Indiana Constitution. Quote, Indiana courts are constitutionally bound by the basic concepts of fairness that are frequently identified with, quote, due process, end quote, in the federal Constitution, end quote. They talk about this case here, Sanchez. For every injury done to him in his person, remedied by due course of law. They say here, Allen was sent to solitary for, quote, safekeeping, end quote, without even a hearing or notice. My question is, what's a safekeeping? Is that the suicide safekeeping? What is that safekeeping? Even when his attorneys informed the court of his dire condition, the court refused to set a hearing in violation of, I believe that's the Indiana Constitution. Although the court eventually held a hearing on June 15, 2023, by that time, the damage was done. Fairness protections in criminal cases are found in different Indiana constitutional provisions. McIntosh versus Melrose. They talk about pretrial punishment violates federal due process. It does violate the Indiana Constitution. Indiana is one of just 6 states protecting citizens from unnecessary rigor. Okay? And this provision requires a, quote, prisoner to suffer severe mistreatment, end quote. So they say recognizing this provision applies to solitary confinement, the Indiana Supreme Court said, the very essence of punishment and the sole use of the prison walls is the confinement of the convict within them. Humanity indeed forbids, as unnecessary rigor, that his confinement should be absolutely solitary, or that his natural and civil rights should be temporarily annihilated. And that's from this case, I believe, here. So they're saying here, Allen's treatment rose to the level of unnecessary rigor. Remember, they're saying you can't have that in pretrial, okay? Rigor is the, quote, act or instance of strictness, severity, or cruelty, end quote. When Allen started suffering from confusion, memory lapses, paranoia, and bizarre behaviors, there was no longer a risk he could not handle the harsh conditions of maximum security solitary. It was a reality. The strictness, severity, and cruelty of his confinement is evident on video where he is screaming in fear, confused about where he is, unable to respond, and drooling and self-harming. The rigor was physical too. And in this case, Williams, they say solitary can result in physical harm, including self-mutilation as a maladaptive coping behavior. Allen lost 40 pounds, was unable to care for himself, was tased, his face was black and blue and at times bleeding, and he was poisoned by fecal matter and toilet water. Indifference to his catatonia is shown where medical staff discuss blood pressure and cholesterol with the vacant Allen. This psychological and physical pain was unnecessary. IDOC could have transferred him upon deterioration as policy requires. Even an isolated infirmary cell would have been better than the, quote, hole, end quote, designed for punishment. Likewise, the court could have moved him when the court learned of his dire condition. The constitutional violations require suppression. I gotta say here, I've had 2 clients that I've had to talk off the ledge from solitary. So this is particularly bothersome for me. And thankfully I was able to do video visits with them. And they credit me with saving their lives because they couldn't take it. They felt helpless. And, you know, we could talk about due process. So this is particularly, I mean, aside from whatever, I don't know. I don't understand this. It's distressing. It's distressing to me. So I don't know. I'm not a medical professional, but I'm just saying this is bothering me because it's bringing back memories. So they're saying the constitutional violations require suppression. They're talking about Dostoevsky. The degree of civilization in a society can be judged by entering its prisons. In 2015, writing about the effects of solitary, Justice Kennedy hearkened to this quote, noting, quote, there is truth to this in our own time, end quote. Applying the exclusionary rule to these constitutional violations would deter abuses within our prison system and law enforcement, protect judicial system integrity by showing it condemns such conduct and protect the human dignity of those unable to make bond while awaiting trial. That's a whole different issue there about bond. And I know there's a safety issue. Indiana has a robust exclusionary rule. Relying on Article 1, Section 11 and 14, Indiana adopted the exclusionary rule long before the Fourth Amendment exclusionary rule applied to the states. Under the exclusionary rule, to determine whether a statement is a product of an illegal detention, the court must ask if the statement, quote, has been come at by exploitation of that illegality or instead by means sufficiently distinguishable to be purged of the primary taint, end quote. So they're talking about the time elapsed between the illegality and the acquisition of the evidence. You know, how much time has lapsed between the bad thing and the confession or the evidence, and the presence of intervening circumstances and the purpose and flagrancy. Flagrancy is the amount of it. You know, how flagrant was it of the official misconduct? So they say, first, Allen's statements occurred during the illegality of his detention at WCU. Second, there were no intervening circumstances. Again, there is a well-known connection between solitary confinement and psychosis delirium. They're talking about Williams again. Third, the constitutional violation was flagrant because IDOC violated its own policies for keeping Allen safe, and the prosecutor refused to help when Allen's attorneys warned of his deterioration. Even if this court finds Allen's statements were voluntary because he was not interrogated by law enforcement, he was still gravely disabled when he confessed. Okay, so they're saying, you know, it wasn't like they sat him down in a chair and shined the light on him and said, you know, you're going to tell us. But he made these statements based on, you know, I don't know that, and this may not be the right word. And again, I'm trying to interpret what they're saying. The aggression of the solitary, right? The looming solitary, right? So it says, you know, he was still gravely disabled when he confessed. As such, his free will did not purge the taint of his illegal detention. The trial court erred by denying the motion to suppress. The error was not harmless. Before a federal or state, quote, constitutional error can be held harmless, the court must find it was harmless beyond a reasonable doubt, end quote. Okay, they're quoting Chapman. He said, quote, no piece of evidence may have greater sway over a jury than a defendant's confession, end quote. The erroneous admission of statements to Dr. Walla alone was prejudicial because they were a large part of the state's case. The prosecutor particularly concentrated on Allen's May 3rd statement, arguing that Allen knew a fact only the killer would know. The confessions also countered Allen's confident and unwavering pre-solitary protests of innocence. 3. The court denied Allen his right to present a complete defense to explain the scene to impeach evidence. Remember we got our three-legged stool here. The 14th Amendment guarantees a defendant the right to a fair trial. The amendment's due process clause places significant substantive limits on state power, prohibiting its arbitrary exertion and guaranteeing criminal defendants, quote, a fair opportunity to defend against the state's accusations, end quote. For a, quote, opportunity, end quote, to be, quote, fair, end quote, a defendant must be permitted to, quote, confront and cross-examine witnesses and to call witnesses in his or her own behalf, end quote. Okay, that's the confrontation clause that we hear about. These overarching principles operate in tandem with the Sixth Amendment, which similarly, quote, guarantees criminal defendants a meaningful opportunity to present a complete defense, end quote, due process. Although trial courts have broad discretion in conducting trials, this discretion has constitutional limits. Says, they're talking about Holmes here, that is, courts may not, quote, infringe upon a weighty interest of the accused, end quote, through decisions that are, quote, are arbitrary or disproportionate to the purposes they are designed to serve, end quote. As explained more fully below, the trial court made several reversible errors under the rules of evidence and Indiana's trial rules. In many instances, these decisions violated the Constitution as well. Standard of review. While this court assesses claims relating to admitting or excluding evidence for abuse of discretion, to the extent those claims implicate constitutional issues, this court reviews them de novo, end quote. They're quoting that case. So they're saying errors in the admission of evidence will be disregarded as harmless, quote, if its probable impact on the jury in light of all the evidence in the case is sufficiently minor so as not to affect the substantial rights of the parties, end quote. So they're trying to say If it's like no big deal, then it doesn't matter, okay? But when the error is constitutional, means you should get it, right? If it's in the Constitution, you should get it, right? We all have those rights. They said the standard is higher. Generally, quote, before a federal constitutional error can be held harmless, the court must be able to declare a belief that it was harmless beyond a reasonable doubt. Okay, so they're talking confrontation and due process. Okay, so they got two of them. Two constitutional issues. B, the court committed reversible error by excluding Blair's sketch of Bridge Guy. At trial, the court prohibited Allen from using Blair's sketch of Bridge Guy. This decision violated our rules of evidence, that's Indiana, and denied Allen his constitutional right to present a defense of mistaken identity. Evidence is relevant when it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Okay, we're going to have to hack that one up. Okay, so we're talking about this sketch, right? So we're going to say the sketch, Blair's sketch, is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action, the trial, the jury, the decision, more probable or less probable than it would be without the evidence. I think that's what that is saying right there, right? So, would having that picture in there be of consequence to the jury determining a fair, right, whether he did it or didn't do it, based on the other information, right? Because them not looking the same, right? The pictures not looking the same and everything, that's kind of exculpatory. Hopefully that makes sense, right? So that's what they're trying to say. So it says, a court may exclude relevant evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Okay, so it's not cumulative because it's not the same. They're not hearing the same thing over and over and over and over again. Well, is it confusing the issues? Well, yeah, it might confuse the issue, but it's a fact. It's a fact as part of the investigation that somebody identified somebody else, right? I mean, Blair, here they say, Blair's sketch proves she did not see Allen on the bridge. Blair did not identify Allen in court as Bridge Guy. But according to the prosecutor, Blair must have seen Allen on the bridge because Allen told us, quote, he went onto the Monon High Bridge out to the first platform, end quote, which is, quote, exactly where Blair saw the Bridge Guy. So is Blair wrong in her aging and her description? Is her eyesight bad? Or were there, two guys on the bridge? Did the sketch artist get it wrong? No, because she said it's 10 out of 10. So who answers to that? Who makes the decision of whether Blair is credible or not credible, or maybe there were two guys, or maybe there weren't two guys? Should that be the jury? Shouldn't the jury see it and go, well, does she know what she's talking about? Does anybody know what they're talking about? Eyewitness testimony. Eyewitness testimony, folks. Right? Have you ever been walking with somebody or something, the same thing? How about this? You're driving down the road and somebody, like, you're the driver, and all of a sudden you go, ooh, because somebody comes in your lane, and the passenger's like, oh my God, I didn't even see the car moving over, right? Like, everybody sees different things. Focus on this in your life. Watch something happen and talk to people in your life and get the versions of the story. It's that telephone game, right? Not even intentionally wrong, badly. It just is, right? So what do you think here? I mean, that's what they're saying. So it says Blair's sketch looked nothing like the person Blair saw. Just 3 days after the murders, Blair met with a sketch artist and described the man she saw on the bridge as white, about 20, of medium build, and having brown curly hair. An artist created the following sketch based on Blair's description. I mean, I know we're talking about the case, but we're just like talking about facts in general. I'm not saying one way or the other. We're just having a conversation about stuff and facts. They say this looks nothing like Alan. At the time of the murders, Alan was short, 44 years old, with closely cropped hair. Blair's sketch also shows that she and Carbaugh saw different people. The state's timeline for the murders is dependent upon Carbaugh and Blair seeing the same person. So are they making the assumption? Are they making the assumption, you know that word, that the two eyewitnesses got it wrong? Because we've got the coat discrepancy, the mud discrepancy, the blood discrepancy, the face discrepancy. So are they going along with, and I say that are not as badly, but we got eyewitness testimony here. Memory's faulty, right? Okay. So what I'm saying here is the prosecution saying, well, this one had a guy on the bridge and this one had a guy on the bridge, and they must just be, their memory isn't so good. Like this one's a guy and this one's a guy, they have to be the same guy. Is that it? And the prosecutor told the jury that every eyewitness, quote, is adamant the person they saw was bridge guy, end quote. Quote, there's no doubt in their minds, end quote. But Blair's sketch disproves this claim. Carbaugh, like Blair, made a sketch. When Blair saw it, she described it as, quote, wrong, end quote, and not who she saw. I mean, how do you not put that in there? I know that's a bad deal for the investigation, but how do you not put that in there? Like, me as a cop, I'd be like, ooh, I got to investigate further. This is where I tell you guys, I don't like gaps. Because, to me, you could have a blind witness. You could have a witness that was under the influence of something and didn't remember properly. You could have some mental process that the memory doesn't encode right. You could have another person on the bridge. I mean, it could have been another day. How do you have to allow for that? You have to account for that, and you have to answer for that. I couldn't just leave it, right? I don't know. That's what I'm saying. What are they saying? They got it wrong? Well, if they got it wrong for whatever reason, that the mud wasn't the mud or the blood wasn't the blood and the jacket wasn't really tan, it was blue, well, then how can you put them in there? Are they not credible? I don't know. We're just asking questions. Just asking questions. You got to ask questions. Okay. Blair's sketch impeaches the investigation and shows law enforcement bias against Allen. For 2 years, law enforcement circulated Carbaugh's sketch without it yielding a single arrest. So in April 2019, Indiana State Police released Blair's sketch, declared it represented, quote, the face of, end quote, bridge guy, and announced that Blair and Carbaugh did, quote, not see the same person, end quote. After Allen's arrest, the story changed. The jury was told Carbaugh and Blair saw the same person. So my question is, after Allen's arrest, the story changed. Jury was told Carbaugh and Blair saw the same person. So Blair testified, but the sketch didn't come in. Did Blair testify and say she saw the same person? That's interesting. Blair's, because I mean, wouldn't you be like, you see, they take the thing and they're like, okay, Your Honor, can I present this to the witness? And they go, I'm holding up exhibit blank, and could you just tell me right here, this is the sketch, and you sat down and this is the one that, that didn't come in? That's crazy. I don't know. I'm not an attorney, right? But that's what they're saying. They say Blair's sketch was reliable and probative of Bridge Guy's identity. Blair contacted law enforcement the day the girls went missing, and it was, quote, very clear, end quote, to her she saw Bridge Guy. And was she the one that her Fitbit or whatever her thingy was, her exercise thingy was on the bridge at the right time? Wouldn't that be more reliable? I don't know. 2 days later, she developed her sketch with an artist and a book of facial features. She rated her sketch 10 out of 10 for accuracy. In 2019, she met with law enforcement repeatedly and she reaffirmed her confidence in her sketch. She insisted that she could identify Bridge Guy if she saw him. Now, did they show her, who's the guy? Horner? The other guy? The Norse people? Did they show her that guy? That would be interesting to see. What's he look like? Again, I know nothing of this case. I'm just reading along with you. Blair's sketch is not hearsay. Indiana bars the use of out-of-court, quote, statements, end quote, for the truth of the matter asserted unless the statement falls within an exception. Here, Blair's sketch was not a, quote, statement, end quote. Although Indiana has not reached the issue, other courts hold that a sketch is the functional equivalent of a photograph. Interesting. Is that why they disbarred it? Or disallowed it? They're saying because it's hearsay because she told it to the sketch artist? Well, what if she made the sketch? What if she made the sketch? I'm trying to think. Let me think for a minute. Okay, so what if, I don't know. I'm assuming or I'm guessing, theorizing, positing, maybe they discarded the sketch as hearsay. So what else would come in that's not hearsay? So what if, because the artist is getting it from her head to the paper. So what if she was asked to describe a car? And she went and she flipped through a magazine displaying photos of cars. Okay, so the magazine is compositing or composing the car and presenting the car, like the artist is composing and presenting the sketch that she sees and then says, yes. Versus the magazine, no, nope. It's that car right there. What do you think? I don't know. Okay. The sketch is not hearsay. A statement is not, quote, hearsay, end quote. Quote, if, quote, the declarant testifies and is subject to cross-examination about a prior statement and the statement, ... is an identification of a person shortly after perceiving the person, end quote. Okay. The rule applies whether the identifying witness makes a positive in-court identification or not. So this sounds, okay, that they were using it for positive suspect identification instead of, in this court case, or this, whatever they're arguing here, the rules. But in this case, defense wants it for a not positive identification. Here, Blair identified Bridge Guy to law enforcement immediately and developed her sketch 3 days later. I thought it was 2 days later. Sorry, all these times, these dates and stuff I have to 2 days later, she developed her sketch. What's up with this stuff, man? See, I catch these little details. So here it says, 3 days later. Blair's sketch is also admissible as an adoptive admission. A statement is not hearsay when it is offered against an opposing party and is one the party, quote, manifested that it adopted or believed to be true, end quote. That occurred here in April 2019. The ISP released Blair's sketch to the public and declared, quote, this is the face of the Bridge Guy, end quote. So that's kind of, dang, It's kind of like, you said it was him. You said it was him. So it needs to come in that it was him. Right? I mean, I'm surprised. I don't know what they cut that out on, what they excluded that on. So it says, they continue saying, Blair's sketch is admissible under Indiana's common law too. Decades before Indiana adopted the rules of evidence, sketches were admissible if the eyewitness took the stand at trial. Even if the sketch was inadmissible hearsay, Allen was still entitled to use it. Quote, state law does not have the last word, end quote, on hearsay. Quoting this case, when identity is crucial to the case, let's see. That's the case they argued on. So they're saying excluding the sketch violated the Constitution. Here the state concedes that Bridge Guy's identity was, quote, crucial to the case, end quote. Right? And they said, at one point, this is the dude. Quote, if we can determine who Bridge Guy is, we can determine who killed AW and LG, end quote. Blair's sketch was critical to Allen's defense of mistaken identity, and the judge's decision to exclude it was arbitrary and disproportionate to any legitimate government interest. That's interesting. The error was harmful under both the constitutional harmless error standard and Indiana's evidentiary standard. There's no dispute the state's timeline depended on 1, Blair seeing Allen on the bridge, and 2, Blair and Carboss seeing the same person. Blair's sketch disproved both points. Excluding it affected Allen's substantial rights and the jury's verdict. The court committed reversible error in excluding Tobin's testimony. Allen tendered William Tobin to explain the scientific community's robust criticism of the AFTE's Toolmark matching methodology. The judge excluded him because he was not a firearms expert. He was untrained in firearms identification, and he did not examine the evidence in this case, and he did not conduct a firearms examination. Interesting. According to the court, Tobin's, quote, testimony does not go to an issue before the jury and lacks relevance, end quote. So it sounds like he was just brought in to provide commentary on the community's criticism of the Toolmark matching methodology, that he was not a practitioner, maybe. They say this violated our rules of evidence and violated Allen's constitutional right to prevent a defense. Could he be impeached? He could have impeached the expert. I don't know. Expert testimony should be admitted if the expert is qualified by, quote, knowledge, skill, experience, training, or education, end quote. And 2, the testimony, quote, will help the trier of fact to understand the evidence or determine a fact and issue, end quote. Indiana adopted this rule to, quote, liberalize, end quote, the admission of expert opinion. So with that word liberal, Tobin was clearly qualified to explain the scientific community's robust criticism of the AFTE methodology. Did they do a Fry or Daubert challenge? Tobin is a nationally recognized expert in forensic metallurgy and material science who has testified as an expert in many cases involving the validity and reliability of firearms and tool marks. Maybe because he testifies how the metal responds more so than the gun, right? He has extensive experience in metallurgy, bullet and lead analysis, Toolmark principles, along with background in statistics. He understands the President's Council of Advisors on Science and Technology, PCAST, which has issued a detailed report criticizing the AFTE methodology. So it's probably like having 2 medical examiners talk about the correct way to do an autopsy or something, right? And so he's against this methodology. I have my own opinions about forensic genetic genealogy, right? So we all have our opinions. Tobin's testimony was essential for assessing Oberg's credibility and determining what to believe. Once an expert takes the stand, their credibility is fair game for impeachment. See, I said that, yes. And a party is free to challenge the expert's methodology with opposing testimony from another qualified expert. Okay, there you go. See, I'm right sometimes. The jury is ultimately responsible for assessing witness credibility and determining what to believe, right? So I'm just going back to that, the jury. Going back to the issue with the Blair sketch, right? It's up to the jury to say, why did Blair draw this one, right? I'm not an attorney, but I'm just thinking in my mind, like you should think in your mind, right? Because we were asking that question about the sketch, should the sketch have come in? Well, it's up to the jury to say, well, if she was there and she was there, how did she draw this guy in his 20s? And how did the other one draw the who's right and who's wrong? Okay. So if they're allowing the experts to duel with their methodology, should the methodology of the sketch, I don't know. Argument. That's what argument, the law. You argue your position. Here, Oberg testified that she matched tool marks on test firings from Allen's gun with tool marks on the unspent cartridge found at the murder scene. Oberg told the jury she found agreement between the tool marks by using the AFTE methodology. I thought it was some. She gave an error rate of 2.2% for false positives and 2.87% for false negatives. She discussed studies and articles that she reviewed to apply the methodology. In over-relevancy objections, she described studies related to guns that were not even Sig Sauer model P239. A lay juror might find this testimony impressive and coherent, but AFTE's methodology is anything but straightforward. Tobin's experience would help a jury understand the scientific community's criticism of AFTE's, quote, subjective, end quote, methodology and force Oberg to engage with that critique. Even if our rules tolerated Tobin's exclusion, the decision was patently unconstitutional. A defendant is entitled to a, quote, a meaningful opportunity to present a complete defense, end quote. This entitles him to impeach a witness, remember our three-legged stool, constitutional, impeachment, trial. Impeach a witness who provides a quote, a crucial link in the proof, end quote, of the defendant's guilt. Although trial courts possess, quote, broad discretion, end quote, to limit impeachment, the discretion cannot be used to arbitrarily exclude competent, reliable evidence bearing on witness credibility when such evidence is central to the defendant's claim of innocence. So they were specifically, as I was saying, it sounds like they were going to bring him in to impeach her. And not that she's a bad person, but that her expertise was bad or couldn't be relied on or was suspect because they were relying on that, whatever AFTE methodology versus the one that Tobin used. Let's see. So it says here, Oberg's credibility was central to the case and the judge arbitrarily excluded Tobin. Tobin is an expert in the AFTE methodology, interesting, and its shortcomings. He is experienced with firearms identification and he examined Oberg's materials. Now, this is a big thing that many times folks don't realize. Experts come in, they have medical examiners come in, and obviously they didn't do the autopsy. Sometimes the autopsy is recorded, they could watch it or whatever, but a lot of times they don't even have the material in their hands. People don't realize that. So all he did was review her reports. So they're saying he is experienced. There was no legitimate interest in excluding him. Allen did not waive his right to appeal the Tobin issue by calling Warren. Says a party aggrieved by erroneous evidentiary ruling is entitled to respond to the improper ruling without sacrificing the right to appellate recourse. So they're saying it sounds like he had a right in the trial before the appeal without sacrificing a right at appeal. So I don't know what, okay. Once the court excluded Tobin, this is what happened. Allen responded by calling Warren who endorsed the use of the AFTE methodology and engaged Oberg in a battle of experts over how to properly apply the methodology to the evidence. This decision did not waive Allen's right to appeal Tobin's exclusion. Okay, so they're saying that just because Allen tried to fight it with Warren, he still wants his other guy, that he feels his other guy should have been allowed, okay? And he should have got it at the trial or the pretrial. He shouldn't have got it. He shouldn't have to burn his appeal, so to speak. They say the error was harmful under both the constitutional standard and the evidentiary standard. The state told the jury Oberg's, quote, never been wrong, end quote. Wow. And that Allen, quote, has, quote, no explanation of how his bullet from his gun ended up between the bodies of AW and LG 6 inches from LG's foot, end quote. Wow. His gun. How his gun? Oh, the bullet from his gun, sorry. Had the jury heard Tobin's robust impeachment of Oberg's methodology, the outcome of this case would probably be different. Was it the same type of bullet? Was it everything the same? Were there fingerprints? Was there DNA? D, the court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its entire case. The state built its entire case upon the following timeline. Allen encountered the girls at 2:13. He completed the murders alone, left LG's phone at the murder scene, was spotted by Carball leaving the scene at 3:56 p.m. 2 hours later, and never returned. If Allen committed the murders, there should be no human-initiated activity on LG's phone after 3:56 p.m., but there was. At trial, Allen called Eldridge, a former FBI forensic examiner, who examined the data from LG's phone and testified that wired headphones or an auxiliary cable were plugged into the phone at 5:45 p.m. on February 13th and then removed at 10:32 p.m. This action would silence a phone call. And she noted the data showed an incoming call moments before the headphones were inserted, suggesting someone was intentionally silencing LG's phone. Since the state claimed Allen left the murder scene at 3:56 p.m., Eldridge's evidence eviscerated the state's timeline and showed someone else committed the murders. The state responded by asking Cecil, its phone expert, whether water damage could simulate headphones being plugged into LG's phone. Over a hearsay objection, Cecil testified he Googled it and found some unspecified non-peer-reviewed, quote, troubleshooting, end quote, forums reporting that it could. Did they find water in the phone? Anybody know that? Cecil's testimony was inadmissible totem pole hearsay. I don't know how to explain that. I don't know what that is. Totem pole hearsay. I don't know what that is. I don't know how to apply the totem pole to it. I mean, I know what a totem pole is, but I don't know what to do with that one. Unless our evidence rules provide otherwise, out-of-court statements are not admissible for their truth. For totem pole hearsay to be admissible, quote, each part of the combined statements must conform with an exception to the rule, end quote. I don't know. Cecil's status as an expert does not affect the hearsay analysis. Statements contained in a, quote, reliable authority, end quote, can be admitted over a hearsay objection when used to, quote, contradict, end quote, an expert who is testifying on the, man, there's typos in here, witness stand. But here the online forum was neither reliable nor used to contradict Cecil. So that's all he could find is the Google. Rule 703 does not avail the state either. Under 703, experts may testify to opinions based on inadmissible evidence if the evidence is of the type reasonably relied on by experts in the field. Rule, however, does not authorize experts to parrot facts that the expert adds nothing to. So they were going to say that he's just parroting Google. He was a mouthpiece for totem pole hearsay that he Googled. The error was constitutional. A defendant is entitled to, quote, a fair opportunity to defend against state's accusations, end quote. This includes the right to impeach a witness through cross-examination when they provide, quote, a crucial link, end quote, in the defendant's guilt. Here the judge arbitrarily allowed the state to undermine Eldridge's testimony with a person's internet post, and it was impossible for Allen to impeach the person through cross-examination. That's interesting. The error was harmful. Eldridge's testimony undermined the timeline upon which the state built its entire case. Allowing the state to rehabilitate the timeline affected Allen's substantial rights and the jury's decision. The court committed reversible error by excluding evidence that impeached the credibility of Allen's confessions. At trial, Allen sought to impeach the credibility of his confessions. The judge made 3 reversible errors. Together, the decisions violated his constitutional right to present a defense. When the defendant confesses, quote, the manner in which the confession was obtained, end quote, is relevant to the confession's credibility. Okay? People have to be credible, they have to be competent, all this stuff. So now they're saying the court erred by excluding the audio from Allen's solitary confinement videos. At trial, Allen moved to introduce 15 videos showing the conditions he endured in solitary confinement. The court sustained the state's hearsay objection and ordered Allen to mute the videos when he showed them to the jury. How's that hearsay if that's video of yourself? This was reversible error. The audio shows a delusional, confused, and disorganized mind. The evidence can only be fully appreciated by listening to it. Accordingly, Allen respectfully requests this court watch the videos with audio. I got a point here. The statements in these videos are not hearsay. Statements are not hearsay when used to prove a defendant's state of mind. This was precisely Allen's purpose in offering the evidence, and the trial court conceded this. So, what popped into my mind is, what if the state said that the defendant confessed during an interrogation in the office, right, in the interview room, and there was no audio, and the defendant is saying no, or there is audio, and the state's like, no, we're not going to play the audio. Would the judge make them play the audio? I would think yes. Okay, so how do you get the audio not in this part? Okay, to the extent there are older cases suggesting that a defendant can never admit his own statements, okay, I don't know about that, I'm not a lawyer, those decisions are inconsistent with and should not survive the adoption of the modern rules of evidence. The audio in the video is also relevant because it impeaches Dr. Wall's testimony and undermines her medical records. Wall's evidence gave the misleading impression that Allen provided organized and detailed confessions with a beginning, middle, and end. But the omitted audio rebuts this, showing a disorganized, nonsensical, and confused Allen. On May 3rd, for example, Dr. Walla describes Allen's mind as, quote, more organized, end quote, than, quote, he'd been, end quote. But the April 28th video puts this statement in context, showing a disjointed, tangential, nonsensical, and rambling Allen. He is plainly psychotic and incredible. The audio also presents a vivid picture of solitary confinement's harsh conditions. Staff talk callously to Allen, guards remark how long feces is on his back, inmates tell him to kill himself, and medical staff ignore obvious signs of SMI and overmedication. In one video, medical personnel ask Allen about his cholesterol and blood pressure while ignoring his catatonia and drool. Without the audio, this video presents a misleading impression that the medical professionals are attentive, when in fact they are not. The error was harmful. The audio shows that Allen's statements in solitary confinement are unworthy of belief. Excluding them therefore affected his substantial rights and likely influenced the jury's decision. Okay, we are almost done. Stay tuned for the next one. Drop your comments. Let me know what you think. All right, we'll see you in a bit.